Hey, this is Kent Jones with Jones and Associates in Cleveland, Tennessee. We serve Cleveland and Chattanooga mostly, but we go outside those areas on an occasional basis. This is going to be part 3A, I guess, in a series that's I wrote a book on in 2015. What do you do if you suffer a personal injury in the state of Tennessee? Um, this is workers' compensation, and workers' compensation differs dramatically from negligence. Essentially, workers' compensation was designed to be a contract between the employee and the employer as to how injuries on the job would be handled. When I started doing it in 1999, it was much different. It was based in the court system, and it was more or less just like regular litigation. It's gone to the Bureau of Workers' Compensation now, so it's administrative. Kind of similar in the sense that you still have some of the tools that you had back then, but and there is a court system within the Bureau of Workers' Compensation. You just don't get to go to local court anymore. If you have an injury within the course and scope of your employment in Tennessee, or an occupational disease, then the notice requirements require you to report that within 30 days of your knowledge of it. It should be in writing, but that's kind of loosely done. And there's also sometimes a rule called a discovery rule that's used. And that was the most dramatic case I had involving that. Was a guy that slipped on ice walking out of a store where he was working, and had absolutely no pain until about 8 months later. Went to a doctor, and the doctor related it all back to the slip and fall. And it's hard to realize that, but sometimes it takes that long for the ramifications of an injury to develop. Once you report an injury, then the workers' compensation insurer or employer is required to give you a panel of 3 physicians to choose from. Typically, you'll get kind of what they call the urgent care places, three of them, and if they feel like you need a referral to a specialist, then they'll refer you onward, and then that will be your authorized treating physician, and so that's how that part of it works. Unlike regular accident claims, the workers' compensation insurer pays for your medical bills. And if you are not able to go to work at all, then they'll take a 52-week wage statement or something similar, unless it's really a short time that you've been there, and calculate an average weekly wage, and you'll be paid 66 2/3% of that until you're not temporarily totally disabled anymore. If you're able to go back to a job with the employer that pays less, then you get 66 2/3% of the difference until you get to what we call MMI. MMI is maximum medical improvement, and I think it's been defined in the additions to the AMA guides for evaluation of permanent impairment as a point when you're not going to get any worse, or you're not going to get too much better. And usually at that point you'll get a rating, and a rating could be anywhere from 0% to 100%, just depending on how serious your permanent disability is. Today, like before, there are multipliers by statute, which you multiply by your impairment rating to find out what your permanent partial disability rating is. Your permanent partial disability rating is a medical rating. You multiply that by a multiplier. The multipliers are a lot lower than they used to be. There still exists the concept of permanent total disability, and that's in what we call very extreme cases where a person just cannot work at any job anymore. And a lot of times when you get into that realm, vocational consultants are used, and those people are usually PhDs who are or master's people that are paid to run you through a series of tests and look at the job market and find out if there's anything that you can go back to. And those benefits, you can't lump sum them anymore. You have to do them on a bi-weekly basis, and they're paid out until you reach the age where you can draw Social Security disability benefits. I'm sorry, Social Security old age benefits. Usually like 65, could be 63, 68, sometimes it differs. And on those cases, you have lifetime open medical care. In all cases, you have the right to lifetime open medical care, but you can close it out for a sum of money if you don't think you're going to need it. That's kind of it in a nutshell, except for the administrative twist to it now. At first, in 1999, I remember you used to just file a complaint, and then you would file a request for, after that, years later, a request for a benefit review conference, which was an informal mediation. And if that didn't work, then you go to regular court. Today, usually a document that's filed is a petition for benefit determination, and that puts you in the system, and you usually go to a mediation either on the phone or in person, depending on what you choose, and if there are any issues such as temporary disability or permanent partial disability, just about anything can be handled there. And again, there is a court. You can go to court and get a ruling. You can appeal that ruling within the system. And be careful, because the time limits on responding to briefs for appeal are shorter than they are under the Tennessee Rules of Civil Procedure. That's about all I'm going to say about workers' compensation now. See an attorney if you have an injury. You'll get quicker results, and of course, the pay schedule is different. Under the law, your attorney is entitled to up to 20% of your net proceeds. We're going to move on in the next section and get out of workers' compensation and back in the realm of traditional injuries, and talk about what you should include in your claim. Thanks a lot. Hope everybody's having a great day, and we'll talk to you.